And so this is Jim Tabery, and he's going to moderate this session.
Thanks, Leslie. Thank you. Welcome back, or welcome, whichever the case may be for you. The first afternoon session will be on multiple actors, and we'll get a couple different perspectives, one from the state level and one from the institutional level. And so our first speaker this afternoon is Sally Milam from the state of West Virginia, where we'll get that state level perspective. She's the Chief Privacy Officer for the executive branch, which covers a variety of different privacy issues. But in particular, she's going to be talking to us today about her experience with, oh, that went back on you, didn't it? Did this jump ahead on you?
I think it jumped a couple.
Yeah. There we go. There you go. Her experience with the West Virginia Healthcare Authority, and she'll talk about privacy law and ethics meets biomedical informatics. So please join me in welcoming Sally Milam.
Leslie asked me to speak to the different standards that impact privacy, and as he indicated, I'm within state government. I have programs that have statewide presence and statewide impact. And so I'll be talking with you about the different laws that impact health information within a state, as well as trying to move information across state lines. So how do the laws differ? And that's really where you start when you build a privacy program. It's called the discover phase. You identify all of your requirements first. When you talk about consumer preferences and you talk about different consent process options and technologies, all of those sort of come further down the road. What you have to do first is to really understand what are all of the different areas of compliance that you need to address. So there have been a number of recent studies that have looked at the impact of health information laws within states, across states, and I'm going to be bringing to you information from those studies as well as information from my own experience so that I can give you something of a survey view of the experience across the country and then the experience in West Virginia. And I want to refer you to the HISTIC reports, that's Health Information Security and Privacy Collaborative, and reports were issued March of 2008, and then a series of reports just recently in January 2009. And at the end of my PowerPoint, I've got notes pages for you with links. And when the slides are on the web, obviously the links will be live. And so you can go directly to these reports. And so really what I'm giving you is sort of an awareness or a survey level. These reports are very rich, they're very deep, and within the half an hour that I have, my intent is to really just sort of brush across the surface to make you aware of some emerging commonalities that are really interesting and might provide us some options and some opportunities that we didn't understand that we had before we had these reports. So the HISTIC Collaborative called Harmonizing State Law developed a tool called the Comparative Analysis Matrix. And I commend that to your reading, and it can be found at the link. What the purpose of that tool is to help states identify their requirements. And I'll talk about why that's a challenge, but it's really nice to have a tool out there that can help you figure out what laws impact privacy, medical information, security, relevant issues, and then a process for prioritizing any attempts at modernization. So are any of the laws really barriers? Many of our laws, as you know, were written for a paper world. We're now electronic with electronic health record systems and health information exchange, and interfaced electronic delivery systems, and we're just in another world, e-prescribing. And so our laws have not kept pace. And so this is a really good tool to help you not only get your arms around the laws and your requirements, but a tool to help you figure out where you need to have change. Now this chart is really, you can't read it on the screen, but Leslie was kind enough to have it printed out. And really what this chart does is just to give you a feel for the differences in privacy. And the question that was asked of 11 states who participated in this HISTIC project is patient consent required in order to disclose PHI to another provider for the treatment of the patient? So when you look at the first chart across the top, that's the non-emergency scenario. The chart below it is the emergency scenario. Green means no consent is required. Red means consent is required. And when you look down the rows, this reactions, medication history, then you look across the column headings, and those are your different types of providers, your sources, hospital, physicians, pharmacists, that sort of thing. And then within each column, each state, there are 11 subcolumns, and each state has a response. So just at a real high level, what this shows you is that there is variation within the non-emergency context. You can see some red in there, in some cases almost 50%. So that's showing you at a glance in the snapshot of states that about half of them require consent in a variety of circumstances. If you look down a column, you can see some green and some red. So that shows you that there are different rules. Jump down to emergency, and that's a lot greener. That reflects just at a glance that you don't have as many consent requirements in emergency. So out of all of the research I've seen on privacy, these charts really, I think, do the best job of just giving you a snapshot of what some of the landscape looks like. This report provides a lot of fantastic information about the differences in laws and a lot about their findings. What they tell us is that the laws are really ambiguous. They're hard to find. They're not located in one place. They don't differentiate between treating providers that are in-state and out-of-state, and that the consent process requirements themselves vary. So they have a lot of very interesting findings that tell you just really the initial stage, identifying requirements, how challenging that is. They also have a lot of much more granular, rich information about specific components of the findings. For example, I found it really interesting when you look at what type of category of organization is most likely to be able to disclose PHI without consent. Anybody want to take a guess? Think about. Well, not none of the states, but what kind of a source doesn't need consent in a non-emergency context? It's your payers. Think about who lobbies the state legislature and where these rules are made. Physicians were the sixth most likely. You've got payers at the top, physicians number 6. What does that say about how our citizens want their healthcare information moving? There's also a lot more really rich information about the types of PHI, the different holders, different PHI receivers, different treatment sources, and that sort of thing. So I really commend this report to your reading. Just this past January, ONC published these 5 reports that are really surveys around these different types of laws, surveys of all of the state's laws. So if you want to get sort of a high-level feel for what's going on in the area, these reports are available, and again, the link is at the end. And what Walter was alluding to, I think, is a really important finding. Most states, and it's interesting, you hear about the variability, and it certainly exists, and there's variability within the state, between states and the feds, but when you strip it down, you look at the non-emergency treatment scenario for general clinical information, you don't have consent requirements. So if we talk about moving protected health information for treatment from one state to another, you don't have the barriers, I think, that we all thought probably existed. And there's even more granular information. They looked at what the consent requirements look like or don't like, and a lot of states fall in the category of defaulting to the HIPAA privacy rule. Some states have no patient consent required, and so forth. So it's a real big deal identifying what your requirements are, and it's a challenge. And as you build a privacy program, that's where you start. You find out what it is that you have to do to be compliant with your laws, and then you look at standards and best practices and NCVHS letters and that sort of thing, and you talk to your stakeholders to find out what you want. But this is the part that's still a little squishy in a lot of states. So this is an example of how West Virginia has gotten its hands around identifying the privacy requirements. And this is just a screenshot of our preemption analysis that sits on our website. In 2003, we developed a public-private partnership to jointly do a preemption analysis that was supported by our state bar, and we had the Hospital Association involved and others involved. And we had a process where everybody pretty much agreed on the outcome of the HIPAA preemption analysis, as well as identification of all health-related laws. And we've updated this preemption analysis every year. It's published through the bar. And it's really our hope that it's something of a quasi-official record of what state laws are preempted, what all of the health information laws are, that sort of thing. So it's our way to get our arms around it. So once you identify all of your laws, that's really just the beginning. And when you, it's our experience in our preemption analysis, we have over 150 health-related laws, and that's what you find when you read the HISPIC reports. There are many, many laws. What you have to do then is analyze them. And you think about who's going to be applying the results of your analysis. We think of some of the gray areas, the decisions we make because of risk. We weigh one law against another. It's often the registration clerks who are dealing with the patients, who are the least paid, have the least amount of education, and who really need very crisp analyses of what they need to do. So this is an example of how we handled one area. And it's a slightly complicated area, not terribly complex, but it requires some analysis before you just tell a registration clerk what you want done. And this is a situation where someone wants access to the records. And in this situation, I'm just showing you a minor. And so HIPAA sort of does a dance with state law, and you do this dance, and you do the analysis, and you figure out where, how an individual can get access to their information. With a minor, this law is very crisp. This slide, when we did this analysis, had no gray areas, but it still looks like a spaghetti salad. You have guardians, you have parents, you have areas where minors have the ability to access their own records, and you can't have a parent accessing. You have healthcare surrogates. So this is an area where the law is really clear, and it still looks like spaghetti, and we're asking our lowest paid people to apply it. This is our minor exceptions. What this tells you is that based on the health condition, are they there? Is it a record about a sexually transmitted disease, or HIV, or birth control, or whatever it is, there's a different answer. And so our attempt to put it in a decision flow chart was to be able to make it crisp for the people making the decisions, to have a way to navigate through the system. And to make this work, we need to do this for everything. It's not enough to have a high-level discussion. When we think about an electronic environment, it needs to be yes or no. It needs to be clear. It needs to be machine readable, as Walter said. So here's our approach to it in West Virginia. As I mentioned, we have to figure out our requirements first. We have to, that's the discover phase. Then you go into the build, and you analyze and you harmonize with health information exchange and your environment and other laws, and then you figure out what your stakeholders want, including your consumers. Your consumers may want something different than your providers. Discussions of what's happening in states, is known across the country. You can have some consumers want very granular consent, but then providers say, there's no way. I wouldn't treat a patient if I couldn't get access to this kind of information. So there's been a very rich debate around how that should work. And it's a very local decision. People feel differently in different parts of the country. So the way we're going to get our arms around 150 laws, all of the best practices, and what our stakeholders want through a negotiation is applying a privacy and security framework. There are a number of frameworks out there that I commend to your reading. ONC has a framework specific to health information exchange. Markle has a framework. The executive branch itself in West Virginia has a privacy and security framework, and the West Virginia Health Information Network, which is West Virginia's statewide exchange, sits within the executive branch. So it's subject to the framework. It needs to meet its requirements. So in essence, what we're going to do is we're going to take individual rights, and we're going to pull all of the laws that impact individual rights and all of the best practices, and we're going to synthesize that with our stakeholders and hear what they want, and those become our output. I can tell you we've gone through this process twice with our committee. It's not easy. We started in 2008, and we had a really well-rounded committee with people representing different areas, especially protected information, business, hospitals, physicians. And I had hoped for the rich debate that I had heard was occurring at different places around the country. And what I found is that it's really hard. When you look at electronic health record penetration rates that are low, you find that people don't have exposure to the electronic environment that they really need to make these meaningful choices. So as we talked about each of these principles and explained explain to them what the compliance foundation looks like and what their options might be and who has done what where, it was too much for them to handle. So what we found is like peeling an onion. So you get the first level of requirements and high-level process requirements, and those are on our website. And I put the link at the end. Then when we did the request for proposal for the technology vendor, we got the group back together, and we had a slightly different focus in terms of identifying the system requirements. What we need to do now is get them back together again, and it's a real educational process. You know, the country's further along, West Virginia's further along. We need to make it real for the people who are weighing these alternatives that will be taken to our board. So that discussion, that challenge, that process applies to health information exchange within the state. But as you can see from this slide, all of our patients don't live in West Virginia. We looked at hospital discharge data and did patient flow and find that we have patients from our surrounding states. Not a surprise. We have patients from Maryland, Pennsylvania, Kentucky, Tennessee, Virginia, and we need to serve all of our patients. So we have a dilemma. What are the rules in the other states? How are their rules harmonized with ours? And what needs to be done to assure our legal and policy compliance? So there's some options that people have identified who've really been thinking about this. And the options come from the HISPIC report as well as a report put out in November by the National Governors Association. And they really shake out into three main areas. You've got a federal option, you have a state option, and a current day approach. In the federal option, this is the first approach would be to have a preemption. You could have HIPAA preempt state law. What that would do would be to get rid of state-specific requirements for specially protected information. Another option would be to look at the NCBHS recommendations in its prior letters and have a uniform way that you would approach specially protected information. And this idea was again brought up by Joy Fritz in the patient permissions paper just published in January, and that really might have some legs. When we look at the commonalities of moving general clinical information, 40 states have a lot of similarity. Perhaps it's really a lot better to get some uniform ways of dealing with these carve-outs. If you can't do it operationally and with the folks that you have and the technology and the dollars, however elegant it is, it's not going to work. There was also the idea thrown out in one of the HISPIC papers of having a special carve-out for when you have one health information exchange that has information given to another health information exchange. So where you're doing an HIE to HIE transfer of information, perhaps that would have an exception to the general consent requirements and the specific consent requirements you have in state law. Downside of the federal action is it's usually slow. You know, how long would it take to get these solutions in place? It'll probably take a while. And you could end up with consent requirements where you didn't have them before. And I've heard states who don't have consent requirements speak pretty hotly. They say that their citizens like it that way. You know, people feel very differently, and that's why we have these different laws. So there's some challenges there. In the state approach, a number of options have been identified. The trading partner or medical referral idea, and that would be developing an interstate agreement of states who share patients. And this agreement could touch any number of areas. You could have an agreement to go after model law, uniform law, regulatory action, or whatever. The challenge to this interstate HIE policy approach is that it could impact the compact clause, which would mean you would need a congressional consent. And so, you know, how easily would that be obtained? How long would that take? The report also indicates that perhaps that could be achieved by having federal agencies' participation in the interstate process as a way to deal with the compact clause. Model laws, uniform laws, regulatory action. A number of areas are suggested to develop model laws around. As we've heard, the medication list, medication history is really important in treatment of the patient. One suggestion is to have a model law around the medication list to develop really a carve-out for that kind of information. Perhaps one definition of emergency. Perhaps a one-time consent for disclosure of PHI held in repositories or moving through a RIO. So these model laws are looking for ways that would get the best bang for the buck, would not touch specially protected information in too much of a way that the participating states would have issues with. The difference between uniform laws and model laws is that the model law approach is really just a lighter version. Oftentimes people who do model laws or model acts don't really intend for the law to pass. It's really more focused on the process. It's an attempt to get thinking going around what the outcome might look like. Regulatory action would be an action by state agencies to promulgate a regulation that would effectuate whatever the content of the model law or the uniform law might be. It also developed an interstate HIE policy framework, and this approach really might have some legs as well. This would really focus on use cases. It would be developing a consent that would take into account the surrounding states' consent requirements. You'd have a consent that everybody would use where you need to share information. And if you think about most states not requiring consent for general clinical information, this would be a way to deal with the outliers. So thinking about the state approaches, it would give you some incremental progress. But again, the legislative process is slow. It could take 3 more years. Model laws and uniform laws are difficult to draft, and they do take a long time, and they take pretty significant resources. The last approach that I've seen put on the table is called the current day approach. And what this approach anticipates is that you have someone in the state who is authorized to say what the state's official position is on a law. I know in my state, I'm not really sure who that person would be. You know, I don't know if it could be the Attorney General. You know, the Attorney General and states offer opinions on different matters. I haven't seen the Attorney General really step into this area other than the new responsibility for HIPAA. So in West Virginia, you know, that's really a new responsibility, obviously, for our Attorney General, and it's yet to be seen. So, you know, if we could, in each state, get someone to decide to work through all of the ambiguity and all of the different laws to come up with an official position, what this would do is to create something of a rules engine, where you take the crisp requirements and you dump them into this big rules engine, and it would spit out what your answer needs to be, based on whatever the rules are. So that's the current day approach. And I'd refer you back to the NGA report again that was issued just this past October. What it does is, in addition to taking each of these different approaches for dealing with interstate exchange, it gives you examples of how each approach has been used in the past, such as with the Uniform Commercial Code or with other laws. Reciprocity, you know, if you get a bar license in one state, it's good in another state, and it has a number of factors and it assigns weights. And so it helps you see, based on a variety of different factors, what approach might be best. And I think it's real helpful to look at them. One of the things that the NGA report stresses, as does the HISPIC reports, is that really the success of whatever option is chosen is really dependent on the strength of the support and the strength of the opposition. So those are the most important factors to consider when we're looking at the different approaches. And then, as I mentioned, I've got links to reports for your information. Thank you.
Okay, we've got a full 15 minutes for questions.
Sure. This is Deborah McGraw, Health Privacy Project, CDT. I sort of feel like I'm missing something in this conversation about the problem of different state laws. Because what I'm struggling with is why your obligation as a healthcare institution isn't just to comply with the law that covers you in your state, versus some conception that if you're treating a patient who resides in another state but comes to you for treatment, that somehow that changes the equation and that patient gets to port their own laws to you that you then need to comply with. So to the extent that some of these systems that we're creating are based on a federated model where the data stays with the data holder and is just, there are sort of terms of exchange, where do the different state laws actually really cause a problem?
Sure. No, we're not anticipating needing to, we don't anticipate the privacy laws following the patient, but we anticipate the patient going to providers in a variety of states. And so then if a patient comes to West Virginia and they live in another state and there's a good chance that they've received care there, we won't know what needs to be in the consent to be able to meet the other state's requirements in order to get them to release information to us. It's not machine readable or interoperable at that point. It would require human intervention.
Anyone else?
Have you looked at any voluntary signing on to a set of proposed uniform rules by healthcare providers, especially big hospitals in a state, and at least get compliance of a critical mass?
I think the NCVHS recommendation kind of goes to that, to the extent that we can have a uniform way to give consent options for specially protected information, which is, I think, what you're suggesting. That might be a way to operationalize those privacy options.
This is Walter Suarez with Kaiser Permanente. Sally, from your perspective, what's your preferred solution? And then what's, I don't want to say the ideal solution, but what would be, what's sort of the more practical solution that can address all these issues? And then what would be the best, if not the ideal?
Well, probably a parallel approach of incremental progress with more nationwide progress at the same time. So with each state receiving, I guess each state received an HIT grant to start health information exchange, and each state has a very short performance period, 4 years. Incremental progress is going to be really important. And so I think given the recent information about commonalities around consent, I think there's probably a lot of room to build on the use case option and develop it with the neighboring states, whether you use an interstate agreement process or not, but to focus on developing a consent that would work for yourself as well as your neighbors. And at the same time, if something like the NCVHS recommendation built upon in the ONC permissions paper, applying it to not only the NIN, but local health information exchange and state health information exchange, having a requirement that we had these uniform approaches would really make things easier from an operational perspective, and I think would make it interoperable across the country, because the incremental approach isn't going to work when you need to send information to the unexpected receiver.
Leslie Francis. So your last slide, the one right before the notes, really suggests that states are themselves deeply confused, right? So that we don't really have a particularly good idea, even within a given state, for most states, of what the privacy regime looks like, largely because it's a patchwork over many, 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 many years and different interests and so on. So your suggestion is that each state should do essentially the kind of inventory that you've worked on doing, and then have somebody that can be a source of questions. Now, if states are that confused, and if it looks like it's going to be really hard to fix that, what do you think are the implications? Do you think it's that what that really suggests is that it's a good idea to have an excellent federal floor rather than saying to states, we really respect federalism in this area? Because it looks like federalism just isn't working particularly well.
Well, I think it's probably fair to say that states are in different places with understanding what their laws are. One state that I can think of in particular has maybe 400 laws that are worse than a patchwork quilt. I mean, they're just minutia over many, many statutes. They know what their problem is and they know where the laws are, but the resources to figure out the problem and then the issue of getting those changes passed through the legislature are other issues. So I think states at this point would need resources and support and a push really to be able to support this current day model. I don't think the resources exist to create an official position or have everything neatly identified. I think it's a challenge.
So I have a question. Could you go back to the slide with all the very helpful colors and states? This is a follow-up on Leslie. I'm wondering about the nature of the confusion. So could you say, is there any, without the actual state names listed, are there generalities in there that you know of? I mean, are we looking at regional differences or red states, blue states, or, you know, the variation at the top? Is there an interesting trend in there that we just don't see yet?
Off the top of my head, I don't know. I think if we went through the appendices to this report and if we look at Joy Pritt's report on patient permissions, we'd find that out. Anecdotally, when I've participated in hearings, I've heard states taking vastly different approaches, and I'm not sure it fell in red or blue states. Walter, do you know? When states, why states are more stringent in their consent requirements? Is it political? Is it their geographic placement in the country? You may know.
Well, I think there are a couple of reasons, I guess. There's more stringent in some areas, and that might be because there were special cases in that state, in that particular area, that raised the attention or caught the attention of legislators that made it, you know, a big issue. And so they now specifically go down and create regulations to become more stringent in that area. That would be one. The other is, you know, I'm speaking like from the state of Minnesota, where I lived in, for a number of years. The privacy regulations are much more overarching. I mentioned earlier that the state has a state law that requires consent for every disclosure, doesn't matter if it's treatment, payment, or operation. And it was passed in early days, even before electronic health information was, you know, the big issue. It was all about exchanges and on paper. And so it was more a philosophical decision made, or of course policy, but across the board decision made by the state legislature, pushed by a lot of the advocacy groups in the state that created sort of a more overarching question of why the state should be going in the direction of a requirement of a consent across the board. One specific issue in Minnesota, for example, is a very unique requirement on research. In Minnesota, you have to obtain consent as sort of almost an opt-in rather than opt-out for research. You have to ask people before you can even go and see their records. And that has made a major impact on how research, and imagine the Mayo Clinic, and my Mayo Clinic testifying at the state legislature 10 years ago, trying to convince the legislature that this was effective significantly in a very negative way, the ability to aggregate population data. It didn't make any difference. And it was primarily you know, the strong role of a number of advocacy people that had the ear of the right legislators at the right time that block any changes to that. So those are some unique intricacies and policy issues at the state and the state legislature that create these kind of effects that then you have a law and it's passed and now it's hard to change it over. So there isn't a single real reason. There's a combination of reasons depending on the state and depending on the situation, some unique factor in a particular state that made that very unique topic to be caught by the eyes of the legislator, or a few people with the right ears of the right legislator, you know, making these cases. So it's a combination of factors.
Thanks, Walter.
I just want to put something on, Leslie Francis again, I just want to put something on the table for the discussion at the end of the day, which is that I think this is an amazingly helpful illustration of how hard it is to have consents follow data. So if I'm in Minnesota at the Mayo Clinic, I get treated at the Mayo Clinic, and I then come back to Utah and consent to have my Mayo Clinic records transferred here. But I think that I'll get asked again if Utah wants to transfer them. I won't, right? Unless Utah has the same rules that Minnesota does. So I may, if I'm treated in a highly protective state and then move to a less protective state, I may think I have protections following my data that I don't. And if I'm treated in a state where records are readily available and I move to a state where I have to give consent, again, I may find myself thinking that records are available when they're not. And neither situation is particularly desirable, but this is a wonderful illustration of that issue.
Got time for about one more question.
Damon Schreitler, I'm an attorney, and so my question naturally would be, are there any grounds for court-imposed solutions, crafting preemption arguments, 14th Amendment arguments, equal protection and liberty interest arguments that could be brought against the states by the likes of the privacy advocate at HHS?
Why, though? I mean, what would the claim be?
I'm asking.
I mean, people bring claims all of the time. You know, I know one of our privacy requirements emanates from a federal district case within the Fourth Circuit. So you find your requirements in common law as well as statutory law, and so people can raise claims all the time, but I'm not sure why the advocates, I mean, if an organization were not following its legal requirements, then they could easily bring suit or have a valid claim, but, you know, I guess I'd have to know more.
Well, in Roe, didn't the federal government, well, that was a private action by Roe, but is it possible that that sort of settled the question and of the disparities between the state approaches? And I'm just wondering if there's...
I see where you're going. Could a lawsuit give us a uniform set of requirements is the question. Yep. It would be nice. It would be a lot quicker. I haven't seen that on the table.
So let's get one more perspective in here, and then we'll move on.
I just want to add some 2 cents to that question, which is that there was actually a constitutional legal challenge filed when HIPAA was enacted but largely by folks who thought that the HIPAA consent regime, which is no consent for treatment, payment, and operations, was in violation of federal constitutional rights from which the right to individual privacy emanates, and it didn't even make it past summary judgment stage. Essentially, that the constitutional right is not one that's absolute. And so therefore, since, Roe has actually, from cases forward, that has been, sort of narrowed in many respects. And so there's always, at each opportunity, this sort of balance. So there certainly has never been, to the best of my knowledge, some indication that there is some overarching constitutional right that gets violated when the federal government and or states, sort of tinker around at the margins here. And certainly from a Commerce Clause perspective, the states are well within their authority to regulate in this space, and HIPAA gave them a wide opportunity to do that. So I struggle also with where you would have a legal basis for a sort of court-imposed solution to all of this. Definitely hasn't worked in the past.
Did you want to add anything, Sally?
No, I agree.
Okay.
But we would welcome it, a declaratory judgment, that would make it easy.
Don't waste your time.
Well, thank you, participants, and let's thank our speaker, Sally Milam.
No damages.